Do you think clinical negligence cases are more complex than personal injury cases?
The idea that just because you sustained an injury, you are automatically entitled to compensation. I think that's a big myth.
My view is that I always want our clients to feel like theirs is the only case that we're dealing with.
And if you don't have the experience, you don't know what the issues are, then on the very first day you take on a case, you could get it wrong.
So you don't know what you don't know.
Don't go to that personal injury lawyer. Always go to a specialist. Go to a specialist solicitor working in a specialist firm.
Hello, welcome to today's episode of Medical Negligence Matters. Today we're going to be looking at the subject of personal injury litigation and clinical negligence litigation and what are the differences and similarities between them. And to help me deal with these questions is my friend and colleague Tony Mitty. Hello, Tony.
Thank you for having me.
So, now the reason I've asked you to be here today is because you have personal experience of the different type of litigation, because you started out your career dealing with personal injury litigation, isn't that right?
It is. I've been qualified for over 30 years now, believe it or not. And throughout my entire time of qualification, I've only ever dealt with injury claims, acting for individual clients in investigating and pursuing their claims. And in a former life, yes, you're right, I was actually a personal injury lawyer, assisting individuals claim compensation when they had accidents either in the high street, at work, or on the roads.
And what led you into clinical negligence work?
It's always been an area of law that I've been very interested in, particularly the relationship and the interplay between the medicine and the law. I wouldn't confess it to being a light bulb moment. It was a gradual realization over the course of my career that this is the subject in law that I wanted to practice. And another important part of the work that I do, and one of the reasons that I'm attracted to this area of work, is to act for the individuals, to investigating claims. I'm not working or acting for a faceless organisation, a corporate being, a corporate organisation. I'm trying to do my best for individual clients who have been injured and harmed through no fault of their own. And I find that to be a very rewarding part of the work.
I think it's good to hear that. I mean, I think that's something that unites, I think, nearly all clinical negligence lawyers, isn't it? It's that idea of acting for the individual against the big
That's right.
corporation or the big organisation.
It does.
That was fighting for the underdog. That may be putting it a bit too strongly, but it's getting a result for that individual makes it particularly rewarding.
It's interesting you should use that phrase because in a sense, individuals against large organisations are underdogs. But our job is to make sure that they don't pursue the process as underdogs. We put them as best we can on an equal footing with large defendants that have resources behind them.
Exactly. It's levelling that playing field, isn't it? I mean, that's a very important part of what we do. And, I mean, how does clinical negligence work differ, in your view, from other types of accident litigation?
Well, let me start off that question by saying how they're similar. When one quantifies a claim for damages for people that have been injured and if they've sustained financial losses, then the quantification process is very similar. And their claims are often divided into the same types of losses. Where it becomes different is in establishing the liability in the first place. Often, in personal injury cases, it can be a fairly standardised process in identifying how a potential organisation, a defendant, is liable. And more often than not, one doesn't require expert evidence. That's not to say that happens in every single personal injury case, because that's not true. There are some very complicated and large value personal injury claims that do require quite extensive evidence. But with clinical negligence claims, invariably every case needs expert evidence, and the whole process of then investigating the claim requires the specialist clinical negligence solicitor to identify what the issues are and to instruct the experts as appropriate. And another big issue between clinical negligence and personal injury claims is the need to establish this so-called causation. It's a routine term that lawyers bandy around all the time, And it can be a very difficult subject to explain to clients. Let me give you an example. If someone sustains an injury at work or in a public place, for example, then it can be quite obvious what the nature and extent of that injury is that they've sustained, and then it's quite straightforward to go on to quantify it. In clinical negligence, and I think you've referred to this in a previous podcast, the idea is that lots of clinicians are treating individuals with significant medical problems in any event. So the key difference in that situation between clinical negligence claims and personal injury claims is establishing the nature of the harm that's been caused by the substandard medical treatment.
Yes, because you're starting from a different place.
You are.
Aren't you?
And of course, it might well be the case that you can establish breach of duty, you can establish liability on the part of the treating clinician, but you might not be able to show that that person has sustained a quantifiable injury as a result of that substandard treatment. And oftentimes in clinical negligence cases, we've got to establish and investigate the but-for scenario. If a client had not been subject and suffered injuries as a result of clinical negligence, what condition would they have been in at the end of the treatment in any event? And
yes, so there might have been some degree of disability regardless of what happened in the treatment.
So there, the lines are blurred. The issue is more fuzzy, if I can use that expression, than a personal injury claim, where, for example, if someone, sad to say, falls over in the high street and breaks their hip, it's obvious what the nature and extent of the injury is likely to be. In clinical negligence, and it's the key difference between investigating a clinical negligence claim and a personal injury claim, this issue of causation. What did the substandard treatment cause? And that can often be not a straightforward issue.
What do you think can go wrong, perhaps, if you have a personal injury lawyer, somebody who's experienced only in dealing with accident claims, taking on a clinical negligence case?
Well, there's two answers to that question. The first answer is the individual. The individual solicitor might not have the experience. And if you don't have the experience, you don't know what the issues are, then on the very first day you take on a case, you could get it wrong.
So you don't know what you don't know?
No. And if you start a case and build a case on shaky footings, it's very difficult to then retrieve it. But not just the individual solicitor. Any specialist clinical negligence solicitor, in my view, should work for a specialist clinical negligence firm, because then you can tap into the wealth of experience and knowledge that working for that firm brings.
So for example, that network of support around you. Yeah,
absolutely right. So at Gadsby Wicks, for example, it's often the case that we have come across similar cases in the past. So it's very easy to tap into our database of knowledge and also discuss case with my colleagues, also clinical negligence specialists, as to what experience they've had in this field. And being able to tap into those resources is just as important. I can't imagine any personal injury solicitor who hasn't done clinical negligence working in a high street firm would not have the wherewithal, both individually and a firm, to take on and pursue successfully these cases.
Yes, it's tricky, isn't it? And do you think, are there any sort of myths about clinical negligence that you come across that from other lawyers or from clients that you think we need to dispel?
I think the key myth is some clients' expectation that just because one has sustained an injury, and of course this applied to personal injury law in much the same way as it does to clinical negligence law, the idea that just because you sustained an injury, you are automatically entitled to compensation. I think that's a big myth. And I think part and parcel of the early process of advising clients is to explain exactly what's involved, that there's no such thing as an automatic right to compensation. And expanding that wider, certainly in the press, if someone has been seriously injured and sustained potentially life-changing injuries that will affect the quality of their life or their loved ones for the rest of their life, then the myth in some quarters of the press is they've secured a windfall. But that's not the case. They've secured compensation to reflect and compensate them for the specific harm that they've suffered.
Yes, and sometimes that could be a lifetime of losses and,
Yes.
and disability. And yes, I mean, the numbers are sometimes enormous, aren't they? And I suppose it makes for good headlines, but that doesn't touch on the reality of the lives of the people who were affected by the injuries.
What the headlines often talk about is just the headline monetary compensation. But below that headline is someone potentially whose life has been ruined and need constant care and support for the rest of their life.
Mm. I think another thing that occurs to me about the difference in clinical negligence, obviously, is that you have got individual clients who have been affected by treatment by other professionals, and there can be a huge loss of trust. Do you think in professions generally? I mean, sometimes I think people come to us with a deep skepticism about all professions having been let down significantly.
Yes. And that's very true, particularly of the clients that we act for, because, of course, they are being treated and have placed their trust, reliance, not to say lives, into the hands of people who you would expect to be trusted, who would expect to look after you. And so when professionals let people down in those circumstances, it is a very difficult and hard thing for clients to bear.
Yeah, I think the emotional toll can be very heavy, can't it, really? And I think from my point of view, I think one of the measures of success for me also is being able to help people get beyond what has happened to them. Because the reality is that most of our clients will continue to need health care. Yes. And to be able, or to help them to go on with that sort of treatment, to restore some level of trust and to feel some confidence in the future, I think is an important
I think you're absolutely right.
Aspect of what we do. Where do you see sort of the biggest tensions between sort of medical practice and legal accountability? I mean, I think a lot of doctors are very nervous and perhaps a bit antagonistic about litigation, and accountability isn't always something that's raised as an issue.
It's not, and to a certain extent, accountability is not necessarily an issue in and of itself that we would get involved in, except to say accountability in the legal sense for causing potentially injuries to our clients. But yes, it's a very fine line, the accountability issue. And I think doctors particularly can be helped by the whole concept of different doctors having different opinions and each one being justified.
Well, that's interesting, isn't it? I mean, it is a point that many of the experts that we have worked with over the years in our cases have said to me how instructive and helpful they have found being involved as an expert in the medico-legal process, in that it informs them about decision-making within their own careers, and I suppose being aware of the things that can go wrong, and trying to avoid those. And I guess we would all hope that lessons are learned from all the cases that we deal with.
I agree. A lot of experts have also told me that what they've learned in investigating and being medical experts has enhanced their own practice immeasurably. But I think another issue on accountability is doctors' accountability to clients to provide them, to our clients, to their patients, with informed advice before starting out on a medical procedure.
Yes, that's interesting. I mean, there's issues of clinical judgment, isn't it? But
yes,
I think that you're right. Informed consent is something which is very topical now, but doctors do find this sometimes quite difficult to get to grips with.
They do, and of course, in any medical procedure, and it's particularly true of surgery, where the consequences can be long-term, it's very important that doctors are accountable to their patients in terms of providing informed consent and providing detailed information about the risks and benefits of different treatment that might even include no treatment at all. And sometimes we see the end of that process when that consenting process has gone wrong. And our clients, their former patients, have not been told of all the risks and benefits, and the doctor or the clinician has not been accountable to their patient by explaining what all the risks and benefits are, and in a sense deciding for the patient what the best course of action is, and not letting the patient decide.
That's right. I mean, I think that sort of old-fashioned paternalistic view of the medical profession, I think, is disappearing. It hasn't entirely disappeared, but I think is much less common, isn't it, these days? I think that most doctors would recognise their obligation really to allow the patient, patient autonomy, to allow the patient to make the decision about what they should and shouldn't do, and as you say, whether to have treatment at all.
Yes.
And the doctor's role is just not to make that decision for them, but to guide them through the process.
Absolutely.
And of course, I suppose that's something that's unique to clinical negligence litigation as opposed to personal injury. Do you think clinical negligence cases are more complex than personal injury cases?
Yes, in certain respects. If we take a general basket of clinical negligence cases and compare them to a general basket of personal injury cases, then I think generally yes. But the complexity is a different mindset. The complexity is investigating in a different way, and the need to instruct experts and read their reports and get to grips with the medical issues involved in their case. Now, I'm not a doctor. I'm not a clinician. But what is important in my line of work and all our line of work is to get to grips as best we can with the medical issues as soon as possible. And that means looking and reading through a client's notes and then identifying and instructing an appropriate expert. These are not issues that actually come up in personal injury law. Oftentimes, the medical records in a personal injury case is just a resource that one uses to instruct an expert to comment upon the nature of the injury and nothing more. But another issue that makes clinical negligence more complex than personal injury law is this whole idea, as I alluded to earlier, of causation, the need to establish what the but-for situation would have been.
And are there any cases that have particularly impacted you, or that you think that have changed the way that you view the system? Or
well, I knew you were going to ask me that question, and I have given it some serious thought, and I'm going to disappoint you, Gillian, because the answer is no. Because over time, every case that I work on is important. Every client is important. Each case is individual. And I've learnt so much from my clients and the cases that I take on that I would not, I don't think, identify an individual case that may have influenced me, because each case I work on in my desk this morning and when I go back to the office this afternoon is important. It's the most important case I'm working on at any given time.
Isn't that the truth? I mean, I think that is something about Gadsby Wicks as a firm, which I think was part of our mission from the outset, was that individual service, and each client is an individual. There are no two cases that are identical, and I think my view is that I always want our clients to feel like theirs is the only case that we're dealing with, and that our entire focus is on that.
Yes.
I think that's a very good point. Have you ever taken over a case from a non-specialist, which you've had to turn around? Is that something that you have come across?
Yes, I have, and they have their own challenges, because, of course, in those situations, our client has not only been let down by a medical professional, but invariably in those cases, they've been let down by a legal professional as well. So we have to build up that trust at a very early stage of taking on that case. And as I mentioned earlier, a lot of problems with these cases stem from the fact that the person was a non-specialist and they got it wrong from the very start. They went down the wrong road. And it's very important to establish that there is a case, to establish what needs to be done quickly, but most importantly, in that situation, to offer reassurance and frankness to the client.
And finally, what would you say to someone who thinks that a general personal injury lawyer can deal with any clinical negligence claim?
Don't go to that personal injury lawyer. Always go to a specialist. Go to a specialist solicitor working in a specialist firm they will have the detailed knowledge and the resources to put at your disposal in pursuing a claim.
And just to sort of wrap things up, I mean, the clinical negligence world has changed a lot. I mean, you've been with us for over 10 years now. And over that time, have you perceived any sort of change in the way that hospitals deal with clinical negligence cases and their attitude to litigation?
The hospital trusts in particular are represented by NHSR, that is the insurance and litigation arm of the NHS, and they will instruct specialist solicitors who themselves then instruct specialist independent experts. And they, in a sense, mirror what we do. And that will never change, I suspect. But of course, throughout regions, one has trusts and individuals that don't investigate quickly or thoroughly. One comes across representatives that aren't prompt, and there can be significant delays in investigation of a claim.
I think my own personal view is that I think some of the defensiveness that was endemic in medical negligence litigation, certainly 30 years ago, has reduced a bit. I mean, I think in the early days, sort of delay, deny, defend was just the mantra, and that was universal.
Yes.
My perception is I think there's a bit less of that these days. I mean, I think that there is a willingness to try and compromise deserving cases earlier. I mean, as you say, there are certain processes that need to be gone through, and that's true on both sides. I mean, nobody would want the NHS to admit to things that unjustifiably. So it's quite right that they should investigate and get their own evidence. But I hope that there is a sort of perhaps a greater move towards more openness in those cases where there's been an obvious failure, and a move to compensate people more swiftly, and I hope that will continue.
Well, so do I.
Tony, thanks very much for being here today.
Pleasure, thank you.